what we believe in is that it's not just by strength that justice is served, but justice is served for all, and it should be equal. And judiciary is the one that enforces it, because we see so often, whether it's in Black Lives Matter or other movements across the world, that justice always tends to favor those with wealth and power. And if you have a stilted judiciary, that's what is going to happen. But with a strong court system, that's the way to make sure justice does what justice is supposed to do, which is justice is meant to be blind in a good way, that irrespective of where you come from, what your color is, what your wealth is, what your background is, it should be, you should get what you deserve in terms of both in good and bad, right? And that's the true judicial system. And mock trials and mock courts are crucial in that. I mean, I spent when I did my law, and Sarusha as well, I'll tell you that we spent more time doing mock trials and mock courts than actually we did in classes. I don't know if that's good, but that's because it was so much fun. So thank you for having me join in briefly. And Vivek, thank you for helping out. I truly appreciate it. Vivek is a terrific lawyer, and I've known for several years, and I'm glad that he was able to work with you guys on this. But I just wanted to say I'm super impressed. Congratulations, and I enjoy doing this. This is great.
Thank you, Mr. Ram, and we're really happy to have both of you on board. It's been an enormous help. So thank you.
Thank you.
Okay, hello everyone, and welcome to ISH's first ever mock trial. Over the past few weeks, we've seen every one of you participants work hard towards making this mock trial the best it could be. And we're very proud to have such enthusiastic and diligent people partaking in this event.
Yeah, while we would love to have hosted this event in person to get a truly authentic experience of what it is like being in the courtroom, as you all know, due to the pandemic, we must resort to conducting this mock trial over the internet. And we do hope you're all safe and doing well in the comfort of your homes. And our participants have worked extremely hard, so we do hope you enjoy today's trial.
Yeah, okay, so just a brief introduction. What you're about to witness is a case revolving a highly scrutinized topic, the death penalty. So the American Civil Liberties Union has taken the state of New York to court to discuss this very matter. The resolution to this issue is what the defendants and prosecutors will be dealing with today.
And now we'd like to pass the torch on to Mr. Vivek, who will just say a few words before we start this event.
Sure, thanks, Advit and Himanjali. I think by now I've had a chance to really see what you guys are working on up close. And as Ram had mentioned earlier, it's really inspiring. As I've mentioned in my previous conversations with people, it's unusual to start mock trials in high school, maybe college, maybe law school, but in high school, sometimes debate team, sometimes other avenues, but this is very ambitious, and it's so great to see so many people interested and involved. The attention to detail, the questions have been really inspiring. And I wanted to make sure that everybody knows that today is going to be fun and that it's our first time. So if there's a hiccup, if there's something that we need to deal with, we will deal with it. And to Advit's point, the US courts are actually online right now. Witnesses are still being called by remote for testimony rather than being gathered in person. So we're pretty close to real life as it is. So don't worry about that. But I think it will be fun to do it in person in the future. I just wanted to also say that whatever people's future interests are, it's really great to see law and the judiciary as an initial spark coming now at 16, 17, 18. I did not think I wanted to do law until after I'd already graduated college in the US at 22, and then went and worked in nonprofit and did some other activities in finance, and then came back to law school around 25, 26. And I think that the Indian system and UK system that allows a bachelor's of law that you could jump into right from your first year of college is one avenue. But the other option is to go and explore first. And especially the way that the world is going these days, I think a long meandering route is just as beneficial and possibly more so than zeroing in and running for it. But these types of activities give you exposure earlier on to that world. And it's been really nice to work with all of you. So if questions come up, I think Akshan is your judge along with, I'm sorry, who's the co-judge, Akshan?
That is Anya.
Yes, so all your questions should be going to Akshan and Anya. They will be deciding on all of the questions and topics that come up. So it's their court, but I'm really looking forward to this. So thank you. Thank you for involving me.
All rise. Department 1 of the Superior Court is now in session. Justices Akshan and Anya presiding, please be seated.
Good morning, everyone. Sorry, rather good afternoon. Ladies and gentlemen, we will be calling the case of the ACLU versus the state of New York. Are both sides ready?
Defendant is prepared and ready to go.
Plaintiff 2.
All right, so the witnesses shall now be sworn in. May the witnesses swear themselves in.
I, Kimberly Davis, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give to the court in this case shall be the truth, the whole truth, and nothing but the truth.
I, Robert Blecker, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give to the court in this case shall be the truth, the whole truth, and nothing but the truth.
Attorneys, please check that all of your witnesses have sworn in.
I, Paul George Castle, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give to the court in this case shall be the truth, the whole truth, and nothing but the truth.
Okay, will the jury please stand? Yeah.
Excuse me, did Frederick Anthony Romano swear themselves in?
Frederick Anthony Romano has already sworn in.
Okay.
Charles Ray Finch is having internet connection issues. Is it fine if she swears herself in via chat?
She can do so when she's being examined.
Thank you.
All right, now we're going to move on. We will begin with the parties introducing their respective members. Can we please have a representative identify each member and the part they will play? Let's start with the plaintiff.
Sure. I, Ishika Adapa, will be first chair on the side of the plaintiff. Anvita Kolipara will be second chair, and Sahil Vora will be associate.
I, Prakhar Raj Varshney, will be the first chair of the defendants. Am the first chair of the defendants. Veer Malhan is the second chair, defendant, and Vanshika Zaveri is defendant associate.
We will start with the opening statements. Can we start with the plaintiff?
Yes. Good afternoon, ladies and gentlemen of the jury. This case is presented on behalf of the ACLU. We believe the death penalty is unjust. This is because there's substantial racial and gender bias in the criminal justice system. We submit killing someone is immoral. It violates both the 8th and the 14th Amendments to the Constitution of the United States. It is not an effective way of deterring crime, and it leads to the execution of too many innocent people. Our national death rows have always held a disproportionately large population of African Americans relative to their percentage of the total population. African Americans and white people are murder victims in almost equal numbers of crimes, but the majority of people on death row are African American. The odds of receiving a death sentence are 4.3% higher in cases with white victims, which is a number that is far too large to ignore. 24.4% of defendants who are less stereotypically Black generally receive a death sentence in murders, while for people who are more stereotypically, the chances of receiving a death sentence for a murder case are 57.5%. In addition to that, sentencing is also based on facial features. According to a 2006 study by Stanford psychology professor Jennifer Eberhardt, those with darker skin, wider noses, and thicker lips are subject to far harsher sentencing. This is proof that the judicial system is racially biased. The death penalty should be abolished, since we submit that killing someone is immoral. Two wrongs do not make a right. If the murder of someone is taken into consideration as a wrong, then killing the murderer is also unjust. Just because someone went against a set of morals and committed a sin, does that mean we lose our own morals in the face of this and in the name of justice? How can it be considered justice if we are losing these same morals only to punish someone else? Killing the convict is rather a form of revenge. We believe that killing someone is immoral in any case. Everyone has the basic right to life, and even if they take someone else's right away, it is still wrong to take away theirs. The death penalty should be abolished because it violates two amendments in the Constitution. The death penalty violates the 8th and 14th Amendment. The 8th Amendment states that nor cruel and unusual punishments inflicted. The death penalty is in violation of this, as evidence proves that death penalty is in violation of this amendment since it classifies under the category of cruel and unusual punishments. The 14th Amendment states that no state shall make or enforce any law, and then goes on to state, without due process of law. The death penalty is in violation of this, as shown by evidence proving that the due process of law is applied differently to different cases based on the person's classifications under the categories of religion, race, and income, when depriving the person's life as a mode of punishment. The 14th Amendment to the Constitution states, no state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the laws. This amendment is being violated, seeing as people of color and people belonging to minority groups are not given equal protection of the laws and are disproportionately sentenced to death by the state. Death penalty is in violation of these amendments, therefore deeming it unlawful. The death penalty is not an effective way of deterring crime. Death row only accounts for a small portion of first-degree murders, and capital punishment accounts for an even smaller proportion. It has not only failed to deter crime, but also increased crime rates. The murder rate in states that follow capital punishment have been 25 to 46% higher than those who don't practice capital punishment since 1990. This proves that the death penalty raises the crime rates in states and in turn makes it even more dangerous for the citizens of these respective states. The death penalty should be abolished because it leads to the imprisonment of many innocent people. It has been proven that 4.1% of the people on death row are innocent. That is almost twice the number of people who have actually been exonerated or set free. This means that there are still many innocent people on death row awaiting their execution. Approximately 120 of the 3,000 people on death row in America may be innocent. This is inequitable as these people have done nothing wrong and they are being stripped of their basic human rights. This is also unjust as killing someone is not the proper way of receiving justice. Revenge is what the death penalty typically actually achieves. For these reasons, we believe that the death penalty should be abolished. Thank you.
Thank you. Now may the defense make their opening statements.
The Constitution of the United States, the supreme law of the United States, begins with 3 words, distinguished by their position on the top of the parchment on which they are inscribed upon and the large strokes of ink in which they are written. We the people. The first 3 words of the Constitution of the United States are we the people. The United States Senate, the upper chamber of the United States Congress, which constitutes the legislature of the United States, states that the Constitution's first 3 words, we the people, affirm that the government of the United States exists to serve its citizens. For over 2 centuries, the Constitution has remained in force because its framers wisely separated and balanced governmental powers to safeguard the interests of majority rule and minority rights, of liberty and equality, and of the federal and state governments. While this is not the legislative branch of the government of the United States, we stand today in the highest court of our judiciary branch and the highest court of our land, the Supreme Court of the United States, whose purpose it is to interpret the law legislated, change or decide the meaning of law, how to apply our laws to real situations, and to deem whether a law breaks the rules of the Constitution of these United States, the supreme law. The highest court of the United States we stand in today has heard the question on the constitutionality of capital punishment or the death penalty many times over the course of nearly the last 140 years, a time span more than half the length of the total history of the United States itself. This Supreme Court, in regards to challenges posed that the capital punishment is unconstitutional, has, for the vast majority of its decisions, and to this day, upheld that the capital punishment is constitutional, even in specific relation to the 5th, 8th, and the 14th Amendment of these United States, time and time again. Capital punishment is also supported by the majority of the public, the people. We, the people, believe in capital punishment. Defendant, the state, hopes to, through witness testimony, expert and non-expert, precedent, factual material, and other arguments, means, and methods, show that capital punishment or the death penalty is indeed constitutional in regards to the 5th, 8th, and 14th Amendments. Thank you.
Thank you. Due to a small technical error, we haven't sworn in the jury yet, so we will do that now. Will the jury please stand and raise your right hand? Thank you. Do each of you swear that you will fairly try the case before the court and that you will return a true verdict according to the evidence and instructions of the court, so help you God? Please say I do.
I do.
I do.
I do.
I do.
You may be seated.
All right, I have one more thing to state. During the direct and cross examinations, when the time is up, which that time limit is 4 minutes, the judge will call time.
Yeah. Okay. The plaintiff may call their first witness.
Okay. Charles Ray Finch, please rise.
Please take the stand.
Please take the stand. Charles Ray Finch.
Present.
Okay. Charles Ray Finch, what history have you had with the justice system's mode of punishment, the death penalty?
In 1976, I was tried for the murder of Robert Holloman, which I had not committed, and hence I was innocently tried. However, I had to spend my life in jail for the next 43 years until I was released last year.
Okay. Mr. Finch, to the best of your knowledge, can you recall how you felt when you were wrongfully convicted for murder and sentenced to death?
I felt victimized and I felt angry because it was not my fault. And I wasn't even given a fair trial because the jury at the time was more racist and I was judged on basis of my color rather than on basis of my actions. So I felt discriminated against and especially victimized.
Mr. Charles, what do you think about the racial bias in the justice system?
I think that there exists a strong racial bias in the justice system because otherwise a person like me should have gotten bail way earlier. And I shouldn't have had to spend my entire life in the confinement, say. And I have no other words for this.
Okay. Speaking of justice, what do you feel about the justice in the case you were involved in?
It was unjust and immoral. I count it as debauchery, and I strongly hold that this was a very unfair trial.
Okay. Do you believe that you were given a fair trial?
No.
Thank you.
Thank you. Does the defendant wish to ask any questions to this witness?
Yes, the defendant does wish to cross-examine Mr. Finch.
Please proceed.
Mr. Finch, you affirmed in a deposition conducted on the 15th of October 2020 that you believe the Constitution of the United States should be upheld. Can you affirm this fact now?
I plead the fifth. I do not remember.
Mr. Finch, are you aware of the 5th, 8th, and 14th Amendments?
I plead the fifth in this because I do not remember.
Mr. Finch, you affirmed in your answer to a question in a deposition conducted on the 15th of October 2020 that you were exonerated of your death sentence in 1977 by the Supreme Court?
I was.
And Mr. Finch, though you didn't know the exact court through which you were exonerated of your life sentence in 2019, you did indeed indicate that you went through a court and due process for your exoneration to occur?
I plead the fifth because I do not remember. That was 43 years ago.
Mr. Finch, To clarify, I am talking about the exoneration from your life sentence in 2019.
which resulted in confinement, and hence I refuse to answer this question. I plead the fifth.
Mr. Finch, I am talking about your exoneration in 2019, not your confinement in
Objection.
19.
Asked and answer. Witness is not answering. Please move on from this line of questioning.
Mr. Finch, you have been through due process, not just convicted, but later exonerated.
I'm really sorry, I could not get you on that question.
Mr. Finch, is it true that you have been through due process to not just be convicted, but later exonerated?
I have not been justly convicted, and I am not able to comprehend your sentence at the moment.
Mr. Finch, let me rephrase. You were tried in court during the process of your conviction in 1976 and then in your exoneration in 2019. Yes or no?
Yes.
Therefore, Mr. Finch, the 5th and 14th Amendments, which state that, therefore, Mr. Finch, do you believe that the 5th and 14th Amendments of the Constitution were upheld?
I refuse to answer.
Thank you, Mr. Finch. This witness is now excused.
Thank you. Does the plaintiff have any other witnesses?
Yes. Kimberly Davis, could you please come on the stand? Okay. How are you related to Troy Davis?
I'm his sister.
What type of man did you know Troy Davis to be?
Troy Davis was a very strong Christian and a very caring brother and uncle. And even during his 16 years on death row, he was still that kind of person. He even taught how to make paper airplanes using wrappers from Reese's Cups to my nephew Dejuan, and how to play football by passing a soda bottle back and forth right there in the visitation room in the prison.
Miss Kimberly, if your brother were still alive in prison, do you believe it would have made a difference to your family?
If my brother wasn't executed and was still alive now, it would have made a huge difference in the world, the biggest difference in the world to us. Not only for me, but for my family and everyone fighting for Troy right now. Even while Troy was on death row, he was able to be a part of the lives of his nieces and nephews, as I stated before. He was able to talk with them, teach them, and he was able to spend time with them. But it would also have meant a lot to his parents, as they would have a lot less stress. And sadly, his mother passed away. And most importantly, it would have given a chance for exoneration if new evidence came to light.
Mrs. Davis, to the best of your knowledge, can you recall how you felt when your brother was convicted for murder and sentenced to death?
It was August 19th, 1989, when Troy supposedly shot Officer Mark Maffei. And it was an absolutely terrible day for my entire family and I. The feeling I had when I found out that it was Troy who was being convicted for murder was simply disbelief. Right from when I heard it, I knew it could not have been true, as my brother was a strong Christian and would never do something that was strictly forbidden by Jesus himself. That day, I wasn't even worried that anything would happen to Troy, as I had enough faith in our justice system, and I trusted that he'd be released once the facts of this case were established. 2 years went on as the fight for his freedom continued, and he was found guilty and sentenced to death. This entire conviction was based on eyewitness testimony and should have never held up, as the witnesses could have easily been either coerced, or they were lying, or they were just fearful. and they may have not even clearly seen who the murderer was. It was complete heartbreak for my entire family.
Okay. Next, do you believe that Troy Davis was given a fair trial?
No, absolutely not. This is because not only was the conviction mainly dependent on eyewitness testimony, that could have and was later proven due to coercion or fear, but the judges weren't even professional during the course of the trial. He was talking to other attorneys and talking about golf and his personal time and when they were going to hang out. They were all on first name basis, and it was not professional at all. It was all fun and games to him.
Why do you believe that Troy Davis is innocent?
I believe my brother's innocent because the man I knew all my life was he was caring, loving, and like I said before, a strongly religious man. He would never do something in open defiance of God, such as committing murder, especially that of a police officer. I
Thank
do
you.
not
Your given
understand that
time
this
is finished. The time you've been allotted is finished. Does the defense wish to question this witness?
Yes, the defense does wish to cross-examine Ms. Kimberly Davis.
Please proceed.
Ms. Davis, in your answer to examination by plaintiff, you'd mentioned that the witnesses who gave eyewitness testimony against your brother, Troy Davis, were coerced and by the method of fear. Is that correct?
Yes.
Therefore, Ms. Davis, can it be extrapolated that you believe emotion can be a biasing factor in the judgment one makes?
I decline to answer that.
Ms. Davis, in a deposition conducted on the 15th of October 2020, you affirmed that your brother, Troy Davis, that you had a brother, Troy Davis, who was convicted of the murder of Mark McPhail with aggravating factor. Is this true?
Yes.
And Ms. Davis, in this deposition, you affirmed that you believed that Troy Davis was innocent of this conviction. Is this also true?
Yes.
Ms. Davis, in this deposition, you affirmed that through due process, your brother was not found innocent of his conviction. Is that true?
I decline to answer.
Ms. Davis, in the aforementioned deposition, you also stated that you believe that the Constitution of the United States must be upheld. Is this true?
I decline to answer.
Ms. Davis, what was the method of execution of your brother?
It was death by lethal injection.
Thank you, Ms. Davis. The witness is excused.
Thank you. Does the prosecution have another witness?
No, we do not, but we were given time to introduce our affidavits in the time of the third witness. Is that still allowed?
Yes, please proceed.
May we first bring your attention to the affidavit of Trent Stadley, the co-author of the study, A Systemic Lottery, the Texas Death Penalty, 1976 to 2016, where he states that defendants who kill a white victim are more likely to be sentenced to death, since 12.9% of victims in murder cases in Texas were white females, yet 35.8% of defendants sentenced to death had killed a white female. He also clearly states, the data clearly allows us to see the emergence of a racialized and gendered victim hierarchy in determining who receives the death penalty and who does not. And the hierarchy places a premium on white lives over Black and female victims over male. Second is the affidavit of one Jack Miner, a former representative at the Michigan House, who, aware of the statistics of the murder rates in death penalty states and non-death penalty states, stated in a House debate that the death penalty is not a deterrent to crime, and the figures would suggest that it's just the opposite. Third is the affidavit of Leonidas Canairis, a professional surgeon who states that he believes execution by lethal injection is just as inhumane as the gas chamber or execution by electrocution. He has also stated that he believes execution by lethal injection is anything but medical, that the people carrying out the injection were unskilled, that the procedure of the execution is not monitored as it should be, and that there is no follow-up to ensure the procedure had worked as intended. Our last affidavit is that of George W. Woodworth, a professor in the Department of Statistics and Actuarial Science at the University of Iowa. He's the co-author of the study that compared jury death sentencing rates for Black defendants and defendants of other races. He stated in the study that eligible defendants who were of African American descent were 38% more likely to be sentenced to death than any other defendant. In his study, he presented data that showed Black defendants were considered worse, regardless of the other factors of the case, such as murder with numerous stab wounds, murder with another felony, and murder caused with great harm, fear, or pain. Thank you.
The court shall call on recess for 5 minutes. Defendant's examinations. Will the defendant bring out their first witness?
Defendants called to the stand Paul George Castle as witness.
Yes.
Mr. Castle, what exactly are your qualifications regarding the field of law?
Yes, I received a BA and a JD from Stanford University in 1981 and 1984 respectively, and I was sworn in as U.S. District Court Judge for the District of Utah in July of 2002.
Thank you, Mr. Castle. Therefore, do you feel that you can accurately speak to the matter of the constitutionality and legality of the death penalty?
Yes, I do believe that.
Mr. Castle, are you aware of the 5th, 8th, and the 14th Amendments of the Constitution of the United States? Mr. Castle?
Excuse me. Sorry. Yes, I am aware of the 3 amendments that you just mentioned.
Yes. Mr. Castle, have you ever written or spoken in your time in the field of law on the death penalty?
Yes, I have.
And, Mr. Castle, have you concluded that the death penalty has the majority support of American people?
Yes, I did. 69% of all United States citizens are in support of the death penalty.
Thank you.
According to a Gallup poll conducted in October of 2007. Apologies.
Thank you. Mr. Castle, within your analysis, did you find that in the sentencing of the death penalty to individuals under due process, that there is no racial bias against African American individuals?
No, I affirm that there is no racial bias in the process.
And Mr. Castle, are you aware of a publication by the Department of Justice of the United States of America in 2001 titled "The Federal Death Penalty System: Supplementary Data, Analysis, and Revised Protocols for Capital Case Review," which indeed affirms that there is no racial bias in the sentencing of the death penalty?
Yes, I am aware of that.
And Mr. Castle, can you affirm that in the presidential ruling of McCleskey v. Kemp in the United States Supreme Court, it was affirmed that aggregate evidence regarding racial bias is insufficient to invalidate an individual defendant's death sentence?
Yes, I affirm that.
Mr. Castle, is it true that the sentencing of one to death penalty must be done through due process only after one is convicted of a crime through due process initially?
Yes, I can confirm.
And Mr. Castle, is it true that in the past and in the present, when a person has wanted to appeal the death sentence that they have received, they have the option to appeal to courts and go through due process for this appeal?
Yes, that is true.
Mr. Castle, have you found the death penalty to have a deterrent effect on further capital crime, as you had mentioned in an affidavit signed on the 15th of October, 2020?
Yes, I do believe that the death penalty has a certain deterrent effect.
And can you speak exactly to this deterrent effect?
Yes, a study by a statistician in the Federal Communications Commission found that each execution deters around 25 murders a year. and it was also seen that according to the multiple regression equation formed by a man named Stephen Lassen, it was found that around each execution in America, it was found that each execution in America did deter murders.
Thank you. And Mr. Castle, based on the answers you've given today, can you conclude in regards specifically to the 5th and the 14th Amendment of the Constitution of the United States, as a former judge and a current law professor, that the death penalty is constitutional and legal?
Yes, I can.
Question. Leading question. Witness is defendant is leading the witness on to an answer.
Sorry.
Sustained.
Okay. Mr. Castle, do you believe that the death penalty in regards to the 5th and 14th Amendment is constitutional?
Yes, I believe so.
Thank you. This witness is excused.
Now, does the plaintiff want to cross-examine?
Yes.
You may go ahead.
Hmm?
I just said you may go ahead.
Thank you. Mr. Paul Castle, in your paper in defense of the death penalty, you have said that, quote, it saves innocent lives by preventing convicted murderers from killing again, end quote. Is that correct?
Yes, I do believe that there's a certain effect of incapacitation due to the death penalty.
It was a simple yes or no question.
Apologies, yes.
Okay. Are you, however, aware of a certain sentence that sentences a convict to life imprisonment?
Yes, I am.
Objection relevance.
Pardon?
Objection relevance.
Okay, sorry. Are you aware that a life sentence is a suitable alternative to the death penalty?
It depends on the case. Depending on the immensity of the offense carried out by the criminal, a death penalty is meted out to them.
So you are aware.
Excuse me. Sorry to interrupt here. Regarding the objection that has been raised by the defendant, that motion is sustained.
Yes.
Just to inform.
So could you please justify your belief that the death penalty should be a part of the law because it prevents convicted murderers from killing again?
Yes, I can provide evidence for this. A man named Kenneth McDuff was sentenced in 1966 for murdering a 16-year-old. He was paroled in Texas and went on to murder 18 other women. Even just looking at that one case, innocent people have died because we failed to carry out the death penalty.
So, Mr. Castle, in your paper, you use the example of Kenneth Allen McDuff as a case for why capital punishment is needed. Is that correct?
Sorry, could you repeat yourself? My internet cut out.
In your paper, you use Kenneth Allen McDuff's example as why capital punishment is needed, correct? As you've just stated?
Yes.
Okay. However, McDuff was released by Texas authorities while serving time. Board members thought he could still, quote, contribute to society, end quote, and so he was released. You acknowledge this fact, correct?
I decline to answer utilizing my rights of the 15th Amendment.
Okay. Okay, Mr. Castle, you're aware that keeping a convict alive in a sentence of life imprisonment does not give them the opportunity to commit more harm to civilians. It's only pardons and paroles that allow them to do so, correct?
I decline to answer utilizing my rights to the 5th Amendment.
Okay. Mr. Castle, would you agree that a direct consequence of no death penalty is not convicts committing crimes again, but rather inaccurate assessments of convicts for changes in sentences?
Could you rephrase the question? I didn't understand the.
Okay. Would you agree that a direct consequence of no death penalty, it isn't that convicts will start committing crimes again, but instead it's that there's inaccurate assessments of these convicts when they want to change their sentences?
Objection, compound question.
Okay, we will break it down. Actually, we will refrain from that line of questioning. You mentioned in your paper that some innocent people will die if we abolish the death penalty. Is that correct?
Yes.
And you are aware that in a study published by the National Academy of Sciences, it says that at least 4% of people on death row were and are likely innocent. Correct?
May I bring to your attention that that according to the studies that I conducted over my
Objection. Narrative answer. Answer called for a yes or no.
Sustained.
No, no, I'm not aware of that.
Okay. Now that we have stated this fact, are you aware?
Your time is finished.
Thank you, witness.
May the
Does the
defendant
defendant-
call their next witness?
Defendant calls to the stand witness Robert Blecker.
You may proceed.
Mr. Blecker, what exactly are your qualifications regarding the field of law?
One
Mr.
second, please.
Apologies.
Your time won't start until the camera's on.
All right.
Mr. Blecker,
please
what
repeat the
exactly are your
question?
qualifications regarding the field of law?
I am a professor of law and I have been awarded the title of an emeritus, which means that I am as credible as a current law representative.
Thank you. Therefore, Mr. Blecker, do you feel that you can accurately speak to the matter of the constitutionality and legality of the death penalty?
Yes.
Mr. Blecker, are you aware of the 5th, 8th, and the 14th Amendments of the Constitution of the United States?
Yes, I am.
And Mr. Blecker, have you ever written or spoken in your time in the field of law on the death penalty?
Yes, I have.
Mr. Blecker, do you claim that the imposition of the death penalty as is today is not cruel and not unusual?
Objection.
Yes.
Leading question.
Sustained.
Mr. Blecker, do you believe that in regards to the pain do you believe that the pain inflicted by the death penalty is fair?
I'm sorry. Could you please repeat the question?
Mr. Blecker, do you believe that the pain inflicted possibly by the death penalty is fair?
I believe that one of the 4 schools of thought on punishment, which is extensively documented in penology, regards retribution, which I believe is in the case of the death penalty being imposed on one who has been found guilty of a capital crime, and that makes the death penalty not cruel nor unusual as a form of punishment.
Thank you. And Mr. Blecker, can you affirm that in the presidential ruling of Bays v. Rees, that it was affirmed that the 3-rug combination used in the lethal injection in Kentucky is constitutional under the 8th
Objection.
Amendment?
Leading question.
I'm
Overruled.
asking. Thank you. Please answer.
Yes.
And Mr. Blecker, can you affirm that in the presidential ruling of Buckley v. Precythe, Justice Neil Gorsuch wrote the majority opinion, joined by 4 other justices, that the 8th Amendment forbids cruel and unusual methods of capital punishment, but does not guarantee a prisoner a painless death?
Yes.
Mr. Blecker, do you concur with the aforementioned majority opinion in the presidential ruling of Buckley v. Precythe?
Yes, I do.
Mr. Blecker, do you believe in regards that the death penalty or capital punishment is constitutional in regards specifically to the 8th Amendment?
Yes.
Thank you. Witness is excused.
Does the plaintiff wish to cross-examine the witness?
Yes, Your Honor.
You may proceed.
Yeah. Mr. Blecker, as you've stated before, you are aware of the 14th Amendment, correct?
Yes, I am.
Are you also aware that 43% of the defendants executed since 1976 are people of color, whereas less than 30% of the United States population is people of color?
I haven't been provided with evidence to support these facts, and I don't know if they are reliable.
Okay. Mr. Blecker, in one of your articles for CNN, you talked about how murderers deserve to die painfully, correct?
I plead my 5th Amendment rights.
Okay. Mr. Blecker, do you believe that dying painfully is cruel?
I wouldn't use, could you please rephrase the question or repeat?
Do you believe that dying painfully is cruel?
I wouldn't use the word cruel. I would say it's incorrect on a moral basis.
Okay. And do you realize that no matter the circumstances, this is a direct contradiction of the Eighth Amendment?
Objection. The Eighth Amendment does not state anything about about pain. It states about uncruel. It states about cruel and unusual punishment.
Could you state what objection you're making? For example, the question lacks foundation.
Yes, the question lacks foundation. The Eighth Amendment does not state anywhere in it. The Eighth Amendment does not mention anything about pain. It is about cruel and unusual punishment.
Sustained.
Okay. We'll move to a different line of questioning. Mr. Blecker, do you believe that capital punishment is a form of revenge for society?
I do not believe that it is a form of revenge.
Could you please state the grounds on which you believe that?
Objection, ambiguous question.
Mr. Blecker, why do you believe that capital punishment is a form of revenge for society?
Objection, leading question. It assumes that Mr. Blecker believes this.
Your Honor, plaintiff is allowed to cross-examine with leading question.
Oh, apologies.
Yeah. Okay. You can proceed.
Mr. Blecker, could you please answer the previous question?
I do not believe that it is a form of revenge. I am a retributivist, and I believe that the punishment should fit the crime, and the death penalty demonstrates this concept.
Okay, and as you've stated before, and as you've just stated, you believe that the death penalty is a basic retributive measure or giving a person a taste of their own medicine, and that it satisfies our deepest instincts for justice, correct?
Objection, compound question.
We are just stating what the witness has previously said. The question was a simple yes or no.
Oh, overruled.
Could you please repeat?
You've stated before, as you've stated just now, the death penalty is a basic retributive measure or giving a person a taste of their own medicine, and that it satisfies our deepest instincts for justice, correct?
I believe that the death penalty is a last resort. It isn't a primary deterrent, and that it's only used.
Objection, narrative.
It's a simple yes or no question.
Yes or no answer.
Excuse me, I must bring to the attention that the plaintiff is not allowing for the judges to overrule or sustain an objection, so you may please give a little more time.
Yes, I believe so.
Okay, so does this mean that you do not believe in giving people second chances or even a chance for new evidence to come to life if it may exonerate them?
The plaintiff, you have used all of your time.
I plead my Fifth Amendment rights.
Does the defendant wish to bring out their last witness?
Yes, the defendant does wish to bring out their last witness. However, before they do so, they would like to use a portion of this allowed time to present 3 affidavits which they have submitted. The first one is the affidavit of John Glover Roberts Jr., who is
How
the
long
Chief
will this
Justice.
take?
This will be within the allotted time. This will be completed within a minute. John Glover Roberts Jr. Is the Chief Justice of the United States and affirms that, as he had stated in the plurality opinion in Bays v. Reese, that an isolated mishap alone does not violate the Eighth Amendment. The affidavit of Paul George Castle, who has already been introduced as in terms of his accreditation, he states that once arrested for murder, in the affidavit, it is stated that once arrested for murder, blacks are less likely to receive a capital sentence than African-American individuals are less likely to receive a capital sentence than are white passing Americans, and also states that via memorandum from Lawrence A. Grenfield to Stephen R. Schlesinger, that of roughly 52,000 state prison inmates serving time for murder, an estimated 810 had previously been convicted of murder and had killed 821 persons following those convictions. Executing each of these inmates after the first murder conviction would have saved the lives of more than 800 people. Lastly, The defendant brings to attention the affidavit of Paul Roberto Zimmerman, who is an economist at the U.S. Federal Trade Commission Bureau of Economics, Antitrust 1 Division. And in his calculation, in a paper he had written titled State Executions, Deterrence, and the Incidence of Murder, shows after significant calculation and account for bias that it is estimated that each state execution deters somewhere between 4 and 25 murders per year, 14 being the average. The witness would now like to, the defendant would now like to call Frederick Anthony Romano to the stand, please.
Yes.
Mr. Romano, are you aware of the 5th, 8th, and the 14th Amendment of the Constitution of the United States?
Yes, I am aware.
Mr. Romano, have you experienced the death of a loved one in your life?
I have.
Mr. Romano, who was this loved one?
She was my sister.
And what is the name of your sister?
Dawn Marie Garvin.
And when did this occur?
November of 1987.
And how did this occur?
We found her mutilated, tortured, and dead in her apartment with 2 others.
My condolences, Mr. Romano. Mr. Romano, after the conviction of Stephen Oken, the murderer, who was proven to be the murderer of your sister, through what sentence under due process did you feel you could find justice for the demise of your sister?
I felt I could find justice through the death sentence.
Thank you. And Mr. Romano, how many years did this process take?
17 years.
And Mr. Romano, did Stephen Oken appeal the death sentence through due process until 2004 from his initial conviction in 1991?
Yes.
Mr. Romano, do you believe that justice for your sister was served when Stephen Oken was executed by lethal injection in 2004?
Yes.
And Mr. Romano, do you believe that the punishment Stephen Oken received for the 3 murders he committed was cruel or unusual?
No, I thought it was justice.
Thank you. Mr. Romano, do you believe in regards that the death penalty is constitutional as per the 5th, 8th, and the 14th Amendment of the Constitution of the United States?
Yes.
Thank you. This witness is excused.
Does the plaintiff wish to cross-examine this witness?
Yes, Your Honor.
You may continue.
Mr. Romano, in a previous interview, you have said, quote, the death fine isn't really revenge, it's the law, unquote, correct?
Yes.
However, wouldn't killing one person for the killing of another be the clear-cut definition of revenge? Would you choose to agree?
No.
Please state the grounds on which you disagree.
I believe revenge would mean me going out there killing one of the murderer's family members. This is just the law.
Okay. Mr. Romano, are you familiar with the 14th Amendment of the United States Constitution?
Yes.
Do you agree or disagree with the statement that people of color are more likely to be wrongfully sentenced?
I disagree.
Could you please state the grounds on which you disagree?
There was a Department of Justice study that said that the proportion of minority defendants in federal capital cases exceeds the proportion of minority individuals in the general population. The information gathered by the department said that the cause of this disproportion wasn't racial or ethnic bias, but the representation of minorities in the pool of potential federal capital cases.
In a previous interview, you have said, quote, the voices of family members of murder victims were drowned out by outspoken death penalty opponents, end quote, right?
Could you repeat?
In a previous interview, you have said, quote, the voices of family members of murder victims were being drowned out by outspoken death penalty opponents, correct?
Yes.
Could you please justify your views on the same?
Objection ambiguous, or apologies, objection retracted.
Sorry, could you repeat the question?
Could you please justify your views on the statement that I've just mentioned?
When I say the family members' voices were drowned out, I mean that we, my family included, because of my sister's death, because of her murder, we suffered. If you just take my parents, this caused so many emotional problems for them, and they had to take so many drugs to keep themselves calm. It's unbelievable.
Mr. Romano, do you believe
Thank you,
that
Ishika. Your time is up.
Okay, thank you, witness.
All right, as that is all concluded, a 5-minute recess will be called. Now, as the closing arguments are going to come out, I would like to state that I would recommend for the prosecution and defense to each take 7 minutes of time approximately, as considering the time we need for rebuttals, jury deliberation, and verdict reading, we have 14 minutes left for the closing arguments. So with that out of the way, may the prosecution use their closing argument.
Sure. Good afternoon, ladies and gentlemen of the jury again. We have just presented all our evidence on why we believe that the death penalty should be abolished. The witnesses we have brought have nothing to gain by lying to all of us, as Charles Ray Finch has already been exonerated, and no change in the justice system will bring back Kimberly Davis's brother, Troy Davis. They're both simply fighting for what they believe to be right. To recap, capital punishment violates both the 8th and 14th Amendments, as it is a cruel form of punishment, and the imposition of the death penalty shows a significant racial bias. Not only that, but probably the biggest flaw with this penalty is that it is irrevocable and can cost an innocent person his or her life. We believe that this itself should be enough to abolish the death penalty. Imposing the death penalty does not give a chance for the defendant to be exonerated. Even if new evidence comes to light, if witnesses recant or change their testimonies, or if found that false evidence was presented. Retributivists have often said that the death penalty is the deserved punishment for people that commit capital crimes. However, the executions are claimed to be swift and in most cases end in a few minutes. This does not give a defendant a chance to reflect on the decisions they have made, nor is it as much of a punishment as the rest of their life behind bars and jail is. We request all of you to see this issue not just as a trial, but as it would apply in the real world. Again, we'd like to bring up the points of the 3 amendments to the United States Constitution that the death penalty violates. Nowhere in these amendments does it mention that the death penalty is an exception, and as it can be inferred by Robert Blecker's cross-examination, dying painfully, while cruel might not be the word that Robert Blecker would use, he insinuated that it was indeed cruel. And while pain might not be mentioned in that particular amendment, the word cruel is, meaning that the defense's witness itself stated that it is in violation of the amendment. Innocent people being executed, the inaccuracy and cruelty of the death penalty, the racial biases that have been inherent. Think of the people who surround you, jury, the families that are affected by this, the irrevocability of this form of justice. Consider the impact this has on communities together and the true constitutionality of this penalty. In conclusion, we hope, after seeing the witness statements and the evidence that we have presented from our side, that you too will agree to abolish the death penalty for all the points mentioned above. Thank you.
This concludes the closing statements of the plaintiff. We have approximately 11 minutes left, so that remaining time may be used by the defendants. Now may the defendants please state their closing statement.
After expert witness testimony and the testimony of Frederick Anthony Romano here today, and the evidence that has been brought to light through affidavits and through these testimonies, the defendants can strongly conclude and show that via precedents, via testimony, via studies by these expert witnesses, via studies in prior United States Supreme Court cases, via all precedent, that the death penalty is indeed constitutional in regards to the 5th, 8th, and the 14th Amendment. The fact that the plaintiff has decided to misconstrue and infer from the cross-examination of defendant witness Robert Blecker is jarring, to be honest. It shows the dishonesty and the way that the plaintiff will bend facts, the same way that the plaintiff did indeed abuse process prior when they did not in a timely fashion share the deposition transcripts of the defendant witnesses. It is clear that the facts have been laid out in favor of the death penalty, in favor of the constitutionality of the death penalty, and to abolish the death penalty would deny justice. Would deny justice to Frederick Anthony Romano and those who feel that they want and seek justice in a way through the death sentence, through the death penalty. There is one due process is followed, as has been stated in the deposition itself, very directly, not in an inferred manner, very directly by Kimberly Davis, that due process is followed. It is clear that in order for the death sentence to be put onto one who is convicted of a crime, one must first be convicted and found guilty of the crime before, in a separate process, they're again sentenced to death. Due process is followed. There's no racial bias that has been shown according to the defendant's affidavits and the defendant's the defendant witnesses' testimonies. It is clear, it is very clear that the 5th, 8th, and the 4th, that the death penalty is not in violation of the 5th, 8th, and the 14th Amendment of the United States, of the Constitution of the United States. And defendants hope that the jury recognizes this, as has been recognized multiple times in the last 140 years of death penalty challenges, that the death penalty is indeed constitutional and that we cannot deny justice through the death penalty to those who seek it. Therefore, abolishing the death penalty would be regrettable. Thank you.
All right, with that concluded, we have a solid 7 or so minutes left. So we will now use that time for rebuttals. Actually, correction, you will be having 1 minute left using for rebuttals. The remaining time will be used to deliberate and
we'd like to show that in fact, it's not the death penalty that lets convicts kill again, but rather the inaccurate assessment of changing in sentences. It has been proved in the affidavit submitted by the prosecution that racial biases are present. The statistics are quite important and can't be ignored here. And we believe that it is not only unjust, immoral for the death penalty to be a part of the law, but also that it is inaccurate, it is inconsistent, and it is cruel. Thank you.
The defendant would just like to state that the defendant's affidavits show the very opposite and lays the determination
Your Honor,
on the
procedural
jury.
question. After the defendant's closing statement, are they still allowed to speak?
Yeah, not now. We've actually exceeded the time that was required for rebutting. I just let a couple of seconds slide for the plaintiff to rebut.
And a procedural question, Your Honor. Was the last sentence or two remark that the defendant first chair just gave, is that going to be admissible?
For convenience sake, can you please repeat the points that you made?
Yes.
The points made were, excuse me, I was talking, the defendant first chair. The points that the defendant first chair made were that the affidavits which the defendant has submitted do speak completely opposite to the affidavits that the plaintiff has provided.
Right, that will be considered during deliberation.
Thank you.
All right, so and I'll point out that the evidence is admissible. Anyways, so now we have to start the jury deliberation. Give me a second. All right, so after this point, you will be sent to breakout rooms. Jury, I'm speaking to you. And 12 minutes will be given as guiding time. Mr. Vivek will be present there to guide you through deliberation. The jury foreman is Tejas, and he will organize and lead deliberations and read out the verdict. Now I call for the breakout rooms to be opened and deliberations to start.
May both legal counsels send in their affidavits as exhibits?
Yes.
Just put it in the general chat.
Hello, is everyone here? Okay.
Yeah.
Yeah, so we have we have 12 minutes to discuss. First of all, I'd like to spend the last 2 minutes for voting. Then 5 minutes I want to spend discussing each different case for both the prosecutor and the defendant. Just to reiterate, I think we have to decide on an option of 3 choices. One, that the capital punishment should be retained by the state of New York. The capital punishment should be amended and reinstated at a later date, or we can decide that the death penalty should be abolished entirely. Is everyone clear with that? Yeah.
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 Turn on the cameras as well. All right. So first we can start with the plaintiff. Do you guys have any thoughts on them? On the points that they raised? Yeah, Anjali.
Can I just ask Mr. Vivek to any opening guiding suggestion he wants to give us before we start the process?
No, I think Tejas seemed to have it under control. Basically, as he pointed out, you have a choice as to what the verdict should be. I think the hardest thing in cases like this is because it became a little bit hypothetical at times. You had them starting to discuss what each other's affidavits said or didn't say, and as jurors, you should just be listening to whatever the facts were that were presented as evidence. It's not the lawyer's interpretation of that. It's not their story. It's not, their emotional appeal. It's what do you think? Who do you think made the stronger argument based on the facts that were at hand? Now, certainly the way in which they did it might play into your consideration, because if you found somebody's argument to be more convincing, then you may start to give more credit to what they were saying and what their position. But make sure that you're doing that because what they have presented is sound and logical, not just because they might have done it in a polished way. That's also important, but that's not that should not have a bearing on your decision. So I think Tejas as foreman is going to present that, but all of you should be asking questions of each other and talking. This period is for you to find out what others were thinking. And see if you had doubts. You could even go back to the judge if you have to, if you want clarification on a particular piece of evidence or want to look at a particular exhibit, you can ask him for that. But otherwise, it's within the confines of the data presented. Your personal feelings and biases from before coming to the jury should be left behind. And it should be based on what you heard today, as opposed to what you might have seen, heard, or thought from before today.
Okay, thank you, Mr. Vivek.
Okay.
Might I speak?
Yeah, you can speak.
Okay, regarding the plaintiff, what I feel personally from what I've witnessed is they used a lot of emotional appeal to get their point across. A lot of morals, a lot of sob stories. They presented one real life witness that corroborated their case. And their line of investigation regarding the racial injustice in court, I feel weren't proven. Their statistics, I don't think the background was explained. To explain where I'm coming from is what they're saying is that more Black people are convicted of murder. And that's the defendant replied with, it's because more people are executed, and that's because more are convicted, right? But they did not provide evidence for why that could be the case, because it can be due to many factors such as economic, maybe family welfare, that there's racial imbalance in the charges, and they did not prove any solid or concrete evidence on that it was the mentality of the judge or the attorneys present in the case that determined the death penalty.
Yeah, actually, a lot of the points that you said were the same as mine. Again, the plaintiff used a lot of pathos. Like they brought about 3 witnesses. 2 of them were from like personal encounters, and then 1 was from an expert. So the main points that I could see that were stated were was the racial bias and the imbalance and the discrimination of minorities when actually delegating the death sentence. Another one was that it goes against the 14th and 8th Amendment. And another thing I noticed was that there's a lot of like statistics used. So for example, one thing that they said was that I think somewhere around like 34% of all the death row, like the people who were in death row were actually African Americans. So yeah, that's what I think the main points are. But then one thing I would say that is hindering the argument of the plaintiff is that you know, they talk a lot about racial bias. Obviously, I think the modern day now, the racial bias isn't as prevalent anymore. So when stating things like the prevalence of racial bias in judicial systems, I think that the sources need to be up to date. So like when I was listening to them, a lot of the sources, they were back in like the 1990s, I think. So I think that the credibility of the sources is something that was hindering their argument. Is there anything else that you guys want to add?
I agree with you. I don't
even be like.
Sorry. I agree with you. I feel like while the plaintiff had a line of investigation that they wanted to pursue, maybe due to time restrictions or other factors, I don't think they achieved the goal.
Yeah. Yash, Abi, Karthik, or Laya, do you guys have anything?
Yeah, I think the same thing as well. I would feel like their line of questioning, their line of investigation came a lot of the questions were based out of racial bias, right? And then so a lot of those questions had a lot to do with racial bias and the more ethical point of view of how it would be like so cruel, or how it would be a not, I guess, a more painful way to go out or something like that. So yeah.
Also,
I also feel the same way.
You can say something, sorry.
Is there anything in particular that you guys really liked?
Also, at the end when they said that, I think I didn't hear it properly, but they said when people are when they're bailed out of prison and they kill more people after they're out. They said something about like something like inadequate analysis or something. Does anyone remember what they said?
The inaccuracy in trying, I think.
Okay.
Yeah.
I think one of their strongest arguments was about how, you know, a lot of times the risk of eyewitness testimonies are not accurate because they can be subjected under a lot of biases. So for like a punishment as severe as a death sentence, you know, the plaintiff said that you shouldn't take the chance to delegate that sentence based on like if it's going to be under like cognitive biases. So I really like that point that they said.
I also think that the plaintiff raised a point about how maybe like a life sentence would be a better alternative to the death penalty, which I thought was a pretty good point, as it would allow this person to feel, the accused, the convicted, to feel regret, and perhaps that would be more beneficial. But again, this is more of a ethical point of view, so it's not quite.
It's still good. Yeah. Rishi?
One of the statistics they gave, they said like the plaintiff, they said that approximately 4% of people on death row are most likely to be innocent. Like
Yeah.
I feel like that goes against what they're saying, because the other 96% they're not innocent. So I felt that what they said didn't make sense to their argument.
All right. Yeah. Anjali?
Like Elias stated,
Hands, by the way, you guys can just speak.
yeah, like Elias stated, first of all, right. So whatever points they brought up again are very hypothetical. They're assuming an inmate who is sentenced to life will feel regret and like the point of prison rehabilitate is what I assume. Right. But as was proven by the defendant or the plaintiff did not give any evidence of that, I would have liked to see maybe a witness come in. I would have liked to see maybe a witness come in and affirm this notion, but since it's hypothetical, I don't think it has the foundation to hold too true.
Yeah. Okay, I think now we can discuss about the points that the defendants brought up. Off the start, I really like the language that the defendant used. It was very formal. He used deductive reasoning. And also another thing was that most of the witnesses that the defendant brought up, they were experts in their field. So I felt that it was a little bit more believable and credible when the
they were appropriate for the occasion because they also had a lot of research done on the specific topic. I think most of the defendants people were educated well on the topic, and I think they had the right to have a really big say. And also they provided a lot of statistics, but I wasn't able to get all of them. But yeah, it was more.
I also think that
reasonable
I also think that one of the witnesses they brought in, where I don't remember his name, but where his sister was mutilated and then he was killed, and then she was like tortured and mutilated. So I think when that happened, and then when the killer was caught, but then he was let out, and then he killed a lot, and then killed 17 or 18 more people, and then he was convicted of the murder. I think that shows if they gave him the death penalty after he was convicted of after he was caught after killing the sister, I think that would have caused none of these deaths to happen, the rest of the 18. So
I just want to clarify that I don't think that's the same case. It was a different one. I think Paul G. Castle said something about the 19 other.
Okay, I think we have to hurry up a little bit. So I think Anjali and then Abhi should speak.
Right. Thank you. One point they brought up was that one of their witnesses took 17 years for for the person that killed their family to be charged.
Yeah.
And the plaintiff's point was that they don't believe in second chances. But as the defendant rightly rebutted it, first you are convicted guilty of the crime, and then you're convicted on regards to the death penalty. Then the defendant actually provided evidence stating that when they were let free without a death penalty, 800 other innocent lives were killed, which I feel is a worse percentage than the alleged killing of innocents in the plaintiff's argument. Then right. The defendant had provided us with 2 or 3 studies done by professionals that stated their research that they have done in the previous years and corroborated and have gotten results, which I don't think was provided by the plaintiff to us.
Yeah.
The plaintiff inferred a lot of the things, which wasn't stated obviously in trial, which I think kind of goes against their mentality since they're trying to remove doubt in all cases. And then again, I don't think we have enough facts and evidence to properly support the plaintiffs, and the affidavits provided by the defendants are, in what I can say, are reliable.
Yeah.
I just wanted to say that I think the defendant produced a lot of counter arguments, good counter arguments, as well as very good counter witnesses. So one of of the witnesses that came up was Frederick Romano, whose sister was unfortunately mutilated and killed. So I think one of the main points by the plaintiff through, like, they wanted people to talk about the sympathy of people and the people on death row. But I think this witness provided a really good counter argument, as the families of the victim who was murdered felt that the only way that they could they felt like they got justice was through the death penalty, as well as the families of
they had to wait 19 years.
Yeah, and then another point I want to make is Paul G. Castle provided a statistic in his book that says 69% of the people of New York believe that the death penalty is just, and this talks more about like what the population of New York thinks and who they really sympathize with, if it's either the victim or the person on death row.
I agree with what Abhi just stated.
Yeah, I was trying to convey the same message earlier, but then I got
Okay, I think we might have to start voting now. Okay, so like I said before, I think there are three choices. Either the death penalty can be retained by the state of New York, it can be amended and reinstated at a later date, or it should be abolished entirely.
Sorry, can you repeat that?
Okay, we can either decide that the death penalty be retained by the state of New York, the death penalty can be amended and stated at a late, or that the death penalty should be abolished entirely. So how many of you guys are for the death penalty?
Can you define retained?
Retained as in, like, should not be changed. This is what the defendant is fighting for, that the death penalty should be there as a form of legal punishment.
Are we raising for retained?
Yeah, so how many of you guys are for the death penalty being retained by the state of New York? How about you, Yash? Okay, I think that's pretty much majority. I think everyone raised their hands. So yeah.
Mr. Vivek, any closing remarks?
Sorry, coming off mute. No, good job. You guys analyzed the evidence. You talked through it. Excellent. nothing else to say. I think take us. How do we go back to the other room now? Sorry.
I think we just leave the breakout room.
Time though.
Oh, it's in the bottom right corner. You can just click leave room.
Yeah.
Okay.
And then leave breakout room. Yeah.
Okay.
Okay, jury foreman, have you reached a verdict?
Yes, we have.
Okay, hold your reading until the judges arrive.
Guys, have all the appropriate people arrived now?
Yes, all right here.
All right then. Jury foreman, please tell the verdict.
So in the case of the ACLU versus the state regarding the abolishment of the death penalty, the jury has found without a reasonable doubt that the death penalty as a form of capital punishment should be retained by the state of New York.
Verdict has been read. Court is adjourned.
Okay, so thank you everyone for coming. Mr. Nicholson is here and I think he could have a couple words to say.
Thank you, Tanya. Thank you, mock trial leadership team and participants. I've just got home from school, so apologies that I missed most of it, but I'm extremely proud of what you've achieved. The documentation will stand you in good stead and the practice will stand you in good stead for a follow-up at some point soon. And I'm keen to watch back the recordings and to learn something from it as a legal novel reader and as a Suits watcher on TV. I've been keen to be an audience member. So congratulations, everybody. Hopefully you've enjoyed it and learnt a bunch.
I just wanted to say thank you to everybody involved. This was really an amazing event, and it was our first trial, and it was fascinating to see how everyone put this together. Even though this was online, it was very well communicated considering the circumstances. Thank you to the teachers who helped us put this together and helped us communicate with Mr. Ram and Mr. Vivek. Their involvement made this so much more authentic, and it really pulled the whole thing off. So thank you, everybody involved, and thank you for everyone who chose to watch. It was great to have you as an audience.